Good morning, thank you. Mr. Altman, good morning.
Thank you, Chair. Chair, the purpose of my remarks this morning is to outline counsel to the inquiry's suggested approach to the making of findings of fact by you under the inquiry's terms of reference. Can I say immediately that a note containing these submissions has already been circulated to all core participants, so that those listening can follow the remarks I'm about to make. Can I set out my headings? First, I'm going to deal with what we submit to be the correct approach to the standard of proof. Second, the type and quality of evidence required to meet the standard of proof. And third, its application to the evidence the inquiry has received during the course of these hearings. Finally, I'm going to deal with the kind of questions which ought to be considered by you before you arrive at individual conclusions on Article 3. So let me start by setting out how the terms of reference relate to the findings that you, Chair, will be considering under Article 3. The terms of reference invite you to reach conclusions about the treatment of detainees held at Brook House during the relevant period, where there is credible evidence of mistreatment contrary to Article 3, that is to say, torture, inhuman or degrading treatment or punishment, and then make any such recommendations as may seem appropriate. Point 1 of the terms of reference states the inquiry will investigate the treatment of complainants, including identifying whether there has been mistreatment and identifying responsibility for any mistreatment. Points 2 to 6 of the terms of reference require investigation of methods, policies, practices, etc., that caused or contributed to identifiable instances of mistreatment. These issues are only relevant to the Article 3 assessment if the failure of those policies, practices, etc., or cumulatively, if the policies or the implementation of those policies were by their very nature of such a poor standard that they would reach the high Article 3 threshold, rendered the detained persons vulnerable or more vulnerable to the identified abuse. It is our view that you should not identify failures in policies and practices alone as amounting to Article 3 violations, but only when they are accompanied by identified mistreatment or abuse that is linked to those failures. We suggest it is open to you to make findings of investigative failures under Article 3, where such failures created the environment in which individual cases of abuse could occur. We submit that there are two essential questions to be answered before any finding regarding the credibility of a claim can be made. First, do the facts give rise to an identifiable incident of physical or verbal abuse capable of amounting to Article 3 mistreatment? And second, if so, does it amount to Article 3 mistreatment? So with that in mind, what are the principles which may be applied when considering the correct standard of proof to be applied when assessing the credibility of a claim of Article 3 mistreatment? The Inquiries Act of 2005 and the Inquiry Rules of 2006 do not assist, as they don't provide for any burden or standard of proof to be applied when an inquiry finds facts. Inquiries have therefore adopted different approaches to the standard of proof as required by the particular factual circumstances. In his ruling on the standard of proof in the undercover policing inquiry, the late Sir Christopher Pitchford concluded, 1, the panel of a statutory public inquiry is not required to adopt any specific standard of proof so long as it acts fairly. 2nd, uniform application of the criminal standard of proof is most unlikely to be appropriate, even in inquiries involving grave conduct. However, this doesn't mean that the chair can't express him or herself as being sure that something occurred if it chooses to adopt a flexible and variable approach to the standard of proof. 3rd, when deciding upon its approach to the standard of proof, an inquiry should have regard to the task which has been set through its terms of reference. So long as he or she acts fairly, the chair is free to decide upon an approach to findings of fact which best suits discharging the inquiry's terms of reference. 4th, the majority of recent public inquiries have found it appropriate to adopt a flexible and variable approach to the standard of proof so as to enable a full and nuanced approach to the determination of facts. And 5th, expressions of suspicion are permissible. They are properly analysed, not as findings of fact, but as comment permitted under Section 24, subsection 1 of the Inquiries Act 2005. Sir Christopher Pitchford acknowledged that recent public inquiries have adopted a flexible and variable approach to the standard of proof so as to enable a full and nuanced approach to the determination of facts, as I say. And he said that most inquiries, including those concerned with homicide, have taken the civil standard of proof as their starting point. He relied in part on the approach in the Baha Musa inquiry. In that inquiry, Sir William Gage, who was the chair, adopted the flexible and variable standard of proof as applied in the Shipman inquiry. He explained his approach at paragraph 1.114 of the inquiry's report, saying, quote, "Where in this report I use such expressions as I am sure or I have no doubt, I will have found a fact to the criminal standard. When I state simply I find, the standard of proof will have been the ordinary civil standard of proof, namely the balance of probabilities. Where it is obvious that I have found a fact but have not used the words I am sure or I find, the standard will have been the civil standard. All other expressions, such as an expression of suspicion, will not be a finding of fact, but will indicate my state of mind in respect of the issue being considered. Chair, we invite you to take a similar approach." The starting point in relation to the appropriate standard of proof, as stated in European court jurisprudence, is that in cases of ill treatment in detention under Article 3, the court should adopt the standard of proof beyond reasonable doubt, or being sure. However, in the case of Anayev and Russia, the European Court found that it has never been the court's purpose to borrow the approach of the national legal systems that use that standard. Its role is not to rule on criminal guilt or civil liability, but on contracting states' responsibility under the Convention. It adopts conclusions that are supported by the free evaluation of all evidence, including inferences that may flow from the facts and the parties' submissions. The European Court said that according to its established case law, proof may follow from the coexistence of sufficiently strong, clear, and concordant inferences, or of similar unrebutted presumptions of fact, adding that the level of persuasion necessary for reaching a particular conclusion, and in this connection the distribution of the burden of proof, are intrinsically linked to the specificity of the facts, the nature of the allegations made, and the convention right at stake. In terms of the quality of the evidence required to prove such an allegation, the European Court in Anayev took into account the objective difficulties experienced by prisoners in collecting evidence to substantiate their claims about conditions in detention. It added that an applicant must nevertheless provide an elaborate and consistent account of the conditions of his or her detention, mentioning the specific elements. Only a credible and reasonably detailed description of the allegedly degrading conditions of detention constitutes a prima facie case of ill treatment. So, Chair, in light of those principles, we consider that the following approach to the standard of proof and to the quality of the evidence should be followed by you. First, a variable and flexible approach to the standard of proof should be adopted, as was favoured in the Baha Musa and undercover policing inquiries. Second, as in the Baha Musa inquiry, the starting point should be to apply the civil standard of proof, in other words, on the balance of probabilities, when determining whether the alleged incident of mistreatment did occur. This recognises the inquisitorial nature of inquiry proceedings as compared with legal proceedings that affect a person's rights, liabilities and obligations, and the fact that no participant in the proceedings has a case to prove. Third, where, however, you are sure, which is the criminal standard, that an alleged incident of mistreatment did occur, it may be appropriate to say so. Fourth, at the other end of the spectrum, where you are unable to reach a conclusion on the balance of probabilities, it may nevertheless be appropriate to record a possibility or a suspicion. Fifth, to find a violation of Article 3, there must be sufficiently strong, clear and concordant inferences or similar unrebutted presumptions of fact. And the supporting evidence must be elaborate and consistent, mentioning the specific elements, credible and reasonably detailed. And finally, sixth, consideration must be given to the difficulties of detained persons in providing corroborating or supporting evidence. Chair, in order to find an allegation credible, you might also wish to consider the following questions. First of all, how clear and detailed is the evidence of mistreatment? Second, are there other similar unrebutted facts that have been established? Third, is a complainant's account of mistreatment consistent with any other account the complainant has given, or with other evidence independent of his account? Fourth, what other evidence is there to support a complaint of mistreatment? And in this regard, the absence of evidence in support is not determinative. Fifth, what is the quality of that evidence? Sixth, is there any evidence that contradicts or rebuts the account? If so, what's the quality of that evidence? And seventh, if rebuttal evidence ought to have existed and doesn't, for example, because there are missing records, what, if any, inferences can be drawn from their absence. Let me now move on, please, to what type of treatment can be considered as Article 3 mistreatment. Article 3 speaks of inhuman or degrading treatment or punishment. The word punishment may be given its ordinary meaning. European court case law tends to focus more on the words inhuman or degrading, while the words treatment or punishment have attracted little attention. But by way of example, the European Court has found that the imposition of a disciplinary punishment by the segregation of prisoners who suffer from serious mental disturbance runs counter to the requirements of Article 3. It would therefore be open to you, Chair, to find that it was punishment, for instance, if a detained person was moved to the CSU, the Care and Separation Unit in Brook House, by the improper or deliberate misapplication of Rules 40 or 42. What about torture? Before treatment or punishment can be characterized as torture, it must be deliberate, inhuman treatment causing very serious and cruel suffering. It has to attain a minimum level of severity, considering all the circumstances of the case, such as the duration, the physical or mental effects of that treatment or punishment, and the age and state of health of the victim. The important point to note is that a very high degree of physical suffering and often humiliation intentionally inflicted by someone acting officially is needed to reach the minimum level of suffering in order to qualify as torture. An episode of relatively short duration wouldn't likely reach the necessary level of suffering and humiliation to qualify as torture. If the treatment or punishment did not amount to torture, the question then is whether the treatment was inhuman or degrading. It is inhuman if it causes intense physical or mental suffering. It is degrading if the treatment arouses in the victim feelings of fear, anguish, and inferiority, capable of humiliating and debasing. And as was said in the case of Rumen and Belgium in the European Court, although the question whether the purpose of the treatment is to humiliate or debase a victim is a factor to take into account, the absence of such a purpose can't conclusively rule out a finding of a violation of Article 3. In terms of vulnerability and mental illness, the case of Rumen sets out the principles to be followed, and they are these. First, detainees are in a vulnerable position and the authorities are under a duty to protect them. Second, detainees with mental disorders are more vulnerable than ordinary detainees. Third, certain requirements of detained life pose a greater risk that their health will suffer, exacerbating the risk that they suffer from a feeling of inferiority and are necessarily a source of stress and anxiety. In such circumstances, there must be increased vigilance in reviewing whether Article 3 has been complied with. And fourth and finally, the assessment must also take into consideration the possibility that a detainee may be unable to complain coherently or at all about how they are being affected by any particular treatment. So, Chair, with all of that in mind, the following non-exhaustive list of questions may assist you when making a determination about whether and what treatment constitutes an Article 3 breach. First of all, was the treatment or punishment physical or verbal? Second, what was the severity of the treatment or punishment? Third, What was its duration? Fourth, was there any racist, religious, or homophobic element to it? Fifth, was there an intention to humiliate and degrade? Sixth, what was the physical or mental effect of the treatment or punishment? Seventh, if it was physical, did the detained person suffer injuries? Eighth, if it was mental, was there mental suffering as a result? Ninth, was the detained person's state of physical or mental health such as to make him more vulnerable to the treatment or punishment? 10th, did the detained person's age make him particularly vulnerable to the treatment or punishment? And 11th, bearing in mind all the circumstances of the case, three further sub-questions, as it were. First of all, was it torture? Did it amount to deliberate, inhuman treatment causing very serious and cruel suffering, such that it attained a minimum level of severity considering all the circumstances? Second, further, or alternatively, was it inhuman treatment or punishment? Did it cause intense physical or mental suffering? And finally, third, further or alternatively, was it degrading treatment or punishment? Did it arouse in the victim feelings of fear, anguish, and inferiority capable of humiliating and debasing? So, Chair, that is all I propose saying by way of closing remarks on behalf of Council to this inquiry. You may now wish to invite the core participants to address you, beginning with Council on behalf of D 1527, D 523, D 2077, D 1538, D 313, D 1914, and Reverend Nathan Ward.
Thank you very much, Mr. Rotman. I'm grateful. Ms. Harrison, thank you.
Chair, if I can just clarify, as I did in opening, it's my intention to make submissions on the systems and institutional failures, the generic issues that arise in the context of this inquiry. I do so on behalf of all of the core participants represented by Duncan Lewis solicitors and Bat Murphy solicitors, but my submissions will be followed by Ms. Morris on behalf of Reverend Nathan Ward. And in terms of addressing the critical question for the individuals, whether there is credible evidence in the case of mistreatment and their links to the systemic and institutional issues that I will outline, that will be addressed first by Mr. Goodman on behalf of the Duncan Lewis core participants, along with Mr. Lee, and finally on behalf of the individual core participants represented by Bat Murphy solicitors, that will be by Ms. Xu Xin-Lu.
Thank you, Ms. Harrison.
And I hope that we can conclude that within the 2 hours that we've been allocated.
So, am I right in understanding that we will hear from you for the first hour, and then I assume at that point we will maybe take our morning break, and then we will pass to others who are going to represent individual clients?
Yeah, I think it's intended that I will conclude my submissions, we'll have the break, and then go on to the... but I get the indication of the hour, and I'm going to try my absolute best.
Thank you.
Can I say then, as we did in opening, we highlighted the two main tasks for the inquiry in its evidential phases. The first was to bring to light the full facts of what happened at Brook House, identify the dangerous policies, practices, management and arrangements that caused or contributed to mistreatment, identify responsibility for any mistreatment, to inform what the remedial course of action is necessary and prevent its reoccurrence. That's of particular importance in this inquiry because, as we now know, there have been numerous past investigations, reviews and test cases, all of which have failed to achieve that critical goal. The second important task for the inquiry in its evidential phases was to give the former detained persons an important opportunity to confront those responsible for their mistreatment and abuse, and on an equal footing. It is an important part of restorative justice to be able to question and hold to account not just the frontline staff who perpetrated acts of violence, physical and mental abuse, humiliation, medical neglect and disregard of their suffering and denial of their human dignity, but also the absent, complicit and complacent senior managers running the centres and sitting in corporate offices of G4S and the Home Office. The latter has always been a priority for the individual core participants who want to ensure that the mistreatment and abuse they experienced is not repeated. This has been at some personal cost for many of them, but they have been willing to relive these traumatic and life-changing experiences to achieve that purpose, putting their experience and their wishes at the heart of this inquiry. In these hearings, as you, Chair, promised, has been achieved. But it now must be your task to deliver that in respect of your findings and recommendations, to ensure, as they wish, that no one else suffers what they did whilst detained at Brook House. Medical Justice and Nathan Ward want the impunity that has marked the system for so long to end. They know all too well from direct knowledge of the institutions and bitter experience that sacking of a handful of custody officers, albeit guilty of grave misconduct, did not begin to identify or address the root causes or contributory factors in the mistreatment that occurred and was allowed to go unchecked for so long. Previous abuse scandals at Oakington in 2005, Yarlswood in 2014, 14 and 15, at Medway, and of course Mr Shaw's review in 2016 that identified practices that were an affront to civilised society. None of this resulted in the change needed to prevent the abuse scandal at Brook House in 2017. Those measures were still not in place to prevent inhumane conditions in Brook House in 2020, as the IMB report so graphically exposed, and they are certainly not present in 2022, and at the time when intense enforcement practices of the past will shortly resume to pre-pandemic levels and incidents. We commend the inquiry for the rigour with which it has sought to fulfil its functions, commensurate with the importance of the rights at stake under Article 3. Once the inquiry went beyond the Panorama programme itself, it has uncovered, through unbroadcast BBC footage, CCTV, body-worn and handheld camera footage, pages of transcripts and reams of documents, and of course the written and oral testimony of the individuals, and the extensive case summaries that Medical Justice was able to provide to the inquiry, that the Panorama programme was not the end and limits of the abuse. This inquiry has uncovered shocking patterns of inhumane and degrading treatment of detained persons, central to which is the overuse and misuse of force and segregation, often without lawful authority or justification, and segregation used as punishment. The normalisation of the infliction of pain, suffering and humiliation, even whilst detained when naked, as we saw in the case of D1234, or even when so emaciated the person could barely hold his own body weight, D2159, is an example of that. In addition, we've seen extensive evidence of the pervasive, violent, derogatory and debasing verbal abuse. And in addition, racism, vitriolic, casual and institutional, underscored by an underlying lack of empathy, even when individuals are at their most distressed and vulnerable, even in life or potentially life-threatening situations. Mr. Collier has told us that even this material relating to use of force is not complete. He identified of the 93 cases of use of force during the period that there may well be other incidents of misuse of force, but the paucity of documentary material, the failure of oversight and investigation, the limits of the PSU complaints procedure means that that full picture is still not and will now never be properly made available to this inquiry. We can say then, without any doubt, This is not a case of isolated incidents by isolated individuals out of sight. This is how the regime operated on a day-to-day basis, and what was the day-to-day experience of those incarcerated within it. It has, of course, been profoundly disturbing to witness repeated physical abuse, the severe mental anguish and denial of human dignity. Both Owen Syred and Callum Tully described alarming incidents of abuse well before April 2017. It has been harrowing to hear the direct evidence of detainees who were brutalised by what Dr. Patterson has described as the corrupted and toxic environment, marked by violence, chaos, disrespect, disregard, and callous indifference to fundamental rights and human suffering. It has been equally disconcerting to listen to custody officers who, even in oral evidence, maintained patently untrue accounts or claimed no memory in the face of uncontrovertible evidence of misconduct and cover-up, and who have sought to deflect responsibility, even to Callum Tully, accusing him of misrepresenting them, inciting them, or failing himself to report the misconduct. Several of these officers still work at Brook House, and whose misconduct was not caught on camera and has only been fully exposed by the inquiry, but they remain in post. Some, like Mr. Loughton and Mr. Dix, have even been promoted. Ben Saunders, the director, adopted not a dissimilar approach to his responsibility for a fundamental failure of management and oversight. He too blamed Callum Tully for not reporting abuse to him. Despite his own obvious culpability, he was allowed to resign and work elsewhere for another private contractor, Mighty, involved in immigration enforcement. In our system of justice, lessons are not learned unless you are willing to confront and accept misconduct, wrongdoing, and failings that harm others. Peter Needon and Jerry Petherick, both G4S senior corporate managers, did not accept their own culpability or responsibility for the dysfunctional senior management team at Brook House, of which they were aware from at least 2014. But at least they recognised that there must have been serious failure on the part of G4S because this abuse and mistreatment occurred. Not so its managing director, Gordon Brockington. With his prepared script, his dissembling evasion and denials, his evidence alone exposes why G4S was not a fit and proper company to have carried on with the contract after 2017 and should not now be entrusted with public functions in the containment and care of prisoners or detainees. The evidence of senior Home Office officials, Mr. Cheeseman, Mr. Schonenberg and Mr. Riley, confirm a state body that is driven by political imperatives to sacrifice welfare on the altar of enforcement and administrative convenience. It relegates safeguarding of detainees to a virtual footnote in a contract that puts cost-cutting over safety and care. It also confirmed the utter disinterest in criticisms of its actions, failures of its policies and practices, whether by oversight bodies, judges, coroners, or its own appointed reviewer, Stephen Shaw. It is clearly cavalier about its legal duties and the adverse impacts on those it detains, and is apparently indifferent to ensuring the necessary changes to prevent the repeated abuse and mistreatment occur. Phil Riley did not look much beyond limited contractual tweaking and increase in staff numbers. He was unable to accept that the original corner-cutting contract that baked in dangerously low staffing levels, a harsh regime and impoverished conditions would have an impact on welfare. Maybe other operations, he speculated, but not welfare. Phil Riley, without irony, said that the Home Office had taken every step we could take proportionately to deliver a safe environment, and claimed that the Rule 35 system had now been improved, and even that there was no systemic failure in 2017. This is of real concern. The same pattern of willful denial of Home Office responsibility. It simply cannot be reconciled with the evidence that the inquiry has heard over many weeks, and to which Mr. Riley even now is apparently oblivious. This is important because it is the mindset and attitudes of men like these who will be responsible for considering and implementing any recommendations the inquiry makes, and it must inform your recommendations. Their attitude and analysis of the events at Brook House provides key evidence for the inquiry's remaining crucial function. To identify my mistreatment and abuse was allowed to reoccur in 2017, again only exposed by undercover reporting. Where and how the detention system, regime, policy and practices sanctioned or allowed it to occur, why lessons have not been learned from past abuse scandals and even from this one 5 years on, and what effective remedial action can now be taken, particularly in the wake of another abuse scandal in Brook House in 2020, where the IMB found the cumulative effect of their concerns amounted to inhumane treatment of the entire population. Fundamental remedial action needs to be taken, and urgently. It is already far too late. The evidence obtained by the inquiry post-Panorama has in no way diminished this imperative. If anything, it has only grown more pressing. Dr. Hard described a deprivation of safeguards to protect detainees from harm was a significant factor in 2017, and it's still continuing. The institutional culture of bullying and intimidation, according to Michelle Brown, one of the longest-serving G4S managers, is also continuing. She says at paragraph 12 of her witness statement, "I left in November 2020 as I still observe bullying and abusive behaviour towards myself, staff and detainees." The IMB's 2021 report found high incidence of vulnerability, mental illness, self-harm, and there is a clear correlation between increased use of force and segregation as the first resort to managing vulnerable detainees, as well as a complete collapse of the Rule 35 process. There is evidence of increased complaints over the use and misuse of force. This is critical to the inquiry's considerations because it shows, without any doubt, that the key themes that have led to a cycle of abuse over many years, including in 2017, still remain very much in play. It also shows that contractual numbers and increased better trained staff, even with a low population, did not prevent inhumane conditions occurring, and which are the breeding ground for excessive and unlawful use of force. It is stark and important to recall the evidence of Mary Molyneux of the IMB on the Home Office's response to their notice of the inhumane conditions operating at Brook House in 2020. She identified a wholly inadequate response. She said there was nothing, not even an acknowledgement. I mean, I knew they had it because we copied it in our people. And then I think nearly 6 weeks later, this response comes in. I don't think it was coincidental that it was received on the day we were giving evidence before the Home Affairs Select Committee. You know, it was a concern about safety, that there is going to be more of this if you persist. It's all about process. That was the Home Office's response. We have the right, we have the process. So there is just a total disconnect and not, in my view, acknowledgement of the problem and the issues we have raised. That evidence is critical for this inquiry and for what it decides to do when identifying recommendations that can address this kind of recalcitrant resistance to recognising the damage and harm that immigration enforcement policies pursued have on vulnerable individuals. We also know from the current healthcare contractor PPG that they cannot make remedial action on the system's failure in respect of safeguards without direction resources from the Home Office. Serco's Steve Hewer could give no assurance that another situation like that identified by the IMB in 2020 could not reoccur. That, he says, is only within the control of the Home Office. Given this, the inquiry needs to identify a fundamentally different approach to previous failed investigations and reviews, not because it is bold or political, but because it is the only rational and logical consequence of where the evidence has taken this inquiry. Alternatives to detention are available and must be found. Current policy fails, but must in any event constrain the use of the power to detain within clearly defined and strict limits. It must prevent its exercise where the person is vulnerable, in particular by reason of a history of torture, trauma, and mental illness, once and for all. This is not a radical conclusion. It was the finding and recommendations of Stephen Shaw in his 2016 review. It has been the recommendation of the HMIP since 2015, as well as that of numerous parliamentary committees and many witnesses to this inquiry. No civilised society should tolerate anything else. The inquiry should also conclude that Brook House must not be used as an IRC. It should follow the conclusion of the HMIP that it is simply an inappropriate environment for administrative detainees, and the expert evidence of Professor Bosworth, which is in fact backed up by all medical evidence, the accounts of some G4S custody officers and senior staff, and of course the experience of those detained there. Looking then at the legal framework and the system's duty that we're here concerned with under Article 3. Article 3 requires states not only to prohibit and punish ill treatment, but also to forestall its occurrence. It is insufficient merely to intervene after its infliction when the physical or moral integrity of human beings has already been irredeemably harmed. Whether the state does so through its policies, practices and arrangements at Brook House reflects paragraph 2 and 4 of the inquiry's terms of reference. In accordance with those terms, the inquiry is tasked not only with making findings of operational failures in individual cases, but also failures at a systems level, and to ascertain whether those arrangements either caused or contributed to the operational breaches and can be changed to prevent recurrence. The forms of harm under Article 3. Although counsel to the inquiry's Article 3 note focuses on physical and verbal mistreatment, the inquiry is also, of course, concerned with mental mistreatment and suffering, including that which flows from naturally occurring physical or mental illness, where it is exacerbated by treatment in detention for which the authorities can be held responsible. This reflects the Grand Chamber's judgment referred to by Mr. Altman in Remain and Belgium. Thus, the conditions of detention which subject a person to distress or hardship or compromise and exacerbate mental health engage the state's responsibility under Article 3, just as physical and verbal abuse. Likewise, a failure to provide appropriate medical care and medical assistance whilst in custody engages the state's obligations under Article 3, and the absence of either can subject an individual to inhuman or degrading treatment. We understand this to underpin paragraphs 4 and 5 of the terms of reference, which must be assessed against the clinical consensus that mental illness cannot be effectively and appropriately treated in immigration detention, nor, as Mr. Shaw found in 2016, can it be appropriately managed. That is why it has always been and continues to be an imperative for policy and practice to prevent detention of the mentally ill and to secure their prompt release if returned. The Strasbourg jurisprudence cited by the Council to the inquiry's note concerns prisons, but it applies to the context subject to one fundamental difference. That is that the question of the legality of the underlying detention and the option for release are not normally an issue in a prison case. The starting point for evaluating the minimum threshold of severity under Article 3 is different, where the detention arose from a discretionary power and where its exercise is unlawful because it is in breach of policy and safeguards to protect vulnerable people in detention. If detention is unlawful, this is highly material to the assessment of whether there was a violation of Article 3 for the period of the detention, because the person is not suffering harm incidental to a legitimate measure and which is inherent in lawful detention. Institutional racism has a special place in Article 3. Counsel to the inquiry's note does not specifically address the case law on institutional racism, but it is plain that where evidenced by explicit racist language of the most offensive kind used here, or the derogatory racial or xenophobic stereotyping, this inherently undermines the dignity of the person on its own and may constitute degrading treatment in breach of Article 3. Racism is recognised to be a special form of affront to human dignity, It will certainly be an exacerbating factor if mistreatment of any kind occurs, as it did, we say here, in the context of institutional racism. Inhumane treatment of the whole centre in 2017. Conditions of detention can cumulatively cause such intensity of physical or mental suffering and anguish that they can constitute inhumane or degrading treatment without deliberate physical mistreatment, not just of individual detainees, but of the whole detained population. This is clear from the IMB's report on the situation in Brook House in 2020. We invite the inquiry to find that the general conditions in 2017 and 2020 bear stark similarities in respect of key features: high numbers of vulnerable detainees, high incidence of self-harm and cases of suicidal risk, the routine use of segregation and force to respond to self-harm, and the complete dysfunction of the Rule 34-35 safeguards with the same harmful consequences, resort to force and oppressive measures in the context of intense pressure of charter flights and no-notice removals. This was a link made by several of the witnesses in their written and oral evidence to the inquiry, and we'll develop that in our closing submissions.
Ladies and gentlemen, may I have your attention, please? Due to circumstances beyond our control, it has become necessary to evacuate the building. Please leave the building immediately.
We're not aware of a test, so we will need to leave, I'm afraid. Thank you. There's a bit of excitement. Thank you, Ms Harrison.
I was going to refer to one individual's experience of these inhumane conditions. D1851, you may recall, gave evidence in the first phase of this inquiry. He gave powerful, compelling evidence about how his experience at Brook House was crushing. He talked in his witness statement of a very stressful and negative environment, would frequently hear detainees being taken by, and they would be shouting and screaming. This created an atmosphere of fear and stress because they would be taken at random times, especially if they were considered a security risk. The Home Office would use a policy of giving them something called a removal window without notice, which added a lot of stress to us in general. I was given one. I felt under a constant apprehension of being removed at any point. This type of environment is toxic because there is no release from the stress. There was simply no break from the stress, and it breaks you inside. You may recall that D1851 was unlawfully detained in Brook House for 3 months. He witnessed disturbed people suffering, hearing and seeing incidents of violence, self-harm, drug misuse, distress and chaos. He witnessed the assault, as Mr Collier found, on his roommate D390 by multiple officers in full PPE and was pinned with a shield to the bed. Even though routine, it was nonetheless terrifying. Despite no pre-existing vulnerability, the cumulative effects caused his mental well-being to erode to the point of developing a mental illness diagnosed as PTSD. Brook House broke his moral and physical integrity. It humiliated him and destroyed his dignity as a human being. He said it made him a different person, and he is not alone. Turning then to the systems breaches and institutional factors that we consider are at the heart of the causes or contributory factors leading to the physical and mental mistreatment and abuse, which created the inhumane conditions at Brook House in 2017. First, we do emphasise the policy context and the hostile environment. Stephen Shaw recognised in 2005 in his investigation into racism and mistreatment at Oakington that the combination of the coercive powers over foreigners involved in immigration enforcement with the attitude towards asylum seekers and other would-be immigrants of some sections of the media can become a breeding ground for racist and abusive word and deed. Whatever the position in 2005, that context has only intensified since. The use of charter flight, no notice removal windows, aggressive policies of immigration enforcement aimed at making the lives of the undeserving unbearable, and the demonising political rhetoric cannot be divorced from the conditions and the attitudes of those officers at Brook House Removal Centre. Reverend Ward gave evidence of a message of hostility as opposed to dignity and humanity already in play in 2014, and other witnesses have given testimony highlighting it as well, including Lee Hanford, Professor Bosworth and Dr. Brodie Patterson. Second, the safeguards systemically fail. It's plain from the evidence received by the inquiry that the safeguards to protect ordinary and vulnerable people from mistreatment in detention are not fit for purpose and continue to be flagrantly and openly breached. This state of affairs has persisted in spite of repeated recommendations by multiple bodies, reports and reviews. A key task of the inquiry is to make clear findings and recommendations that can finally bring this to an end. The adults at risk policy, the centrepiece of the response to Shaw, is structurally deficient as an effective safeguard, and we now know intentionally so. It removed the strong presumption against detention. It removed the assumption that those who are vulnerable are at risk of harm and required evidence to be provided, leading to actual harm before release is considered. The policy reintroduced by the back door the notion of satisfactory management that Stephen Shaw heavily criticised and found an affront to civilised values. Mr. Cheeseman did not dispute this. No Home Office witness could explain how a policy purporting to strengthen protections for vulnerable detainees has in fact achieved the opposite, and why no remedial action has since been taken following Mr. Shaw's second review in 2018 and the repeated extortions of the Chief Inspector of Borders on a number of occasions in recent reports. There was no independent advocacy provision to facilitate people with serious mental illness whose capacity is impaired to participate in decision-making, to challenge detention and segregation. That had been found by the High Court in the case of VC, which has been referred to on a number of occasions in this inquiry and in the evidence of Naomi Blackwell, had ruled that this state of affairs was a breach of the Equality Act 2010 for disabled persons and unlawful. That was in 2018, but still no remedy. Mr. Cheeseman recognised it was necessary, but provided no explanation for why that systemic failure continued. The actions taken against the Gatwick Detainee Welfare Group and Naomi Blackwell, one of its former caseworkers, for facilitating VC's access to legal representation to bring the Article 3 breach to an end is a salutary insight in the extent to which G4S and Home Office managers Mr. Dix and Mr. Gasson actively deterred oversight and scrutiny, even when key to exposing mistreatment and in respect of the most vulnerable detainees. Disconnect between policy and practice. The inquiry's clinical expert, Dr. Hard, concluded that there was a complete systems failure of the safeguards. Where they did operate, they were dysfunctional. Sandra Culver, then the current head of healthcare, and Dr. Uzarali, the current lead GP, still at Brook House, gave evidence that these were systemic deficiencies across the detention estate and that they are continuing. Those failures include GP appointments under Rule 35 coming completely disconnected from their statutory and safeguarding purpose. Rule 35 reports not being done at the first opportunity. We know now that only one Rule 35 assessment a day is being undertaken at Brook House. That's an effective abandonment of the rule and its statutory purposes. We know, and it's been repeatedly referred to, that the process rarely results in a Rule 35-1 report, even though that's the one that is most likely to secure release. And shockingly, there has been no Rule 35-2 reports ever done at Brook House. Dr. Hard properly described this as shocking. The majority of Rule 35-3s do not contain the relevant information on impact, and so the Home Office refuses to release. Even if all these hurdles are overcome, the Home Office release statistics on Rule 35-3 remain woeful and inadequate. None of the officials or even the medical professionals appear to recognise the gravity of their dereliction of duty to those in their care or the consequent risk of serious harm through exacerbation of mental illness and trauma, exactly the kind of harm that Article 3 is intended to avoid and to protect. The alternatives proposed of Part Cs and ACDT have all been roundly rejected as acceptable alternatives by Dr. Hard. The fact that they were also rejected by the High Court in 2017, again, is another indication of the way in which the Home Office disregards legal judgments and its legal obligations. Critical, then, is the evidence from Dr. Hard and Dr. Bingham about the interrelationship between these systems' failure and the mistreatment that occurred at Brook House and can reoccur now. They both said, and this also is the medical advice of Professor Katona, medical evidence of Professor Katona, that it is impossible to separate these systemic failures of the safeguards from the mistreatment of detainees. These failures meant that vulnerable people were not released and were kept in an environment known to have a serious negative impact on mental health for indeterminate periods and suffering a level of harm that engages Article 3 of the Convention. In many individual cases, it's also combined with the treatment of symptoms of deterioration such as distress, self-harm and suicidality as refractory or manipulative behaviour, leading to segregation imposed as a punishment and to the use of force as a routine response. Chillingly, because Dr. Hard explained Much of the default use of force and containment in this context is for convenience, and because, he said, there is nothing else that can be done. That's the position that medical justice and the Royal College of Psychiatrists have explained for a very long time. Dr. Bingham called this a perfect storm for abuse and ill treatment to occur and reoccur. Dr. Hard agreed. There is a clear correlation between this system's failure and the incidence of ill treatment. Fourth, the prisonisation of Brook House is another institutional factor that leads to and led to risk and actual mistreatment. We know that Brook House was designed as a Category B prison, and for all those who visit it or are held within it or work within it, it's a prison in all but name. Little, if anything, can be done to remedy its harsh, brutal features. Mr. Buey reiterated in his evidence the long-standing position that it is an inappropriate environment for administrative detainees. The Home Office itself understood the regime to be inconsistent with the ethos and requirements of a relaxed immigration detention under Rule 3, but cutting corners and cost saving was prioritised over welfare and dignity. The poor physical state of the cells, the squalid, unclean conditions, the lack of natural light and poor ventilation recklessly introduced 3 men's cells with open toilets, inadequately screened, failed to respect the privacy and dignity of the men held there. The centre was chaotic, noisy, and was ridden with spice, a situation out of control, and even involving staff bringing drugs into the centre. In that context, a critical issue for this inquiry is the cross-application of prison policies and methods, such as ACDT, segregation, and the use of force, through control and restraint methods that are properly described as prisonisation by Professor Bosworth and are strongly criticised by her as inappropriate and wrong. These prison policies and measures were and still are coercive custodial risk management tools aimed at controlling and managing high-risk prisoners. They are not designed for the specific risks and needs of the IRC demograph, a high proportion of whom suffer from post-traumatic stress disorder, anxieties and other mental illness arising from a history of torture or ill treatment. Many custody officers explained how they were completely ill-equipped to cope both with the harsh environment and in particular to respond to the high levels of vulnerability and mental illness. That fact led to a process of desensitisation, where the resort was to methods such as use and force and segregation without proper consideration of the individual's vulnerability. Evidence of systemic misuse of the power to segregate under Rule 40 without lawful authorisation and as a punishment has been identified by the inquiry. And of course, there's the widespread unlawful de facto segregation on E-Wing and the CSU operated outside of the constraints of Rule 40. What was also identified in this context as 100% unacceptable, according to Dr. Hard, was the complicity that doctors and nurses at Brook House played in approving and at times sanctioning the use of force, restraints and segregation. Dr. Uzarali did not seem to understand his role. Dr. Hard and Dr. Bingham highlighted a clear conflict of dual loyalties of the worst kind, allowing Home Office priorities to override the doctor's primary duty of care to his patients, and a fundamental safeguarding role of medical practitioners failed in Brook House. This context leads to key aspects of institutional culture in which use and misuse of force led to mistreatment. Desensitisation and dehumanisation are the hallmarks of the culture that operated at Brook House. Faced with acute levels of vulnerability and distress, in the absence of tools or know-how how to deal with it, the inevitable response, Professor Bosworth said, was for custody officers to become desensitised. In that context, the macho, aggressive culture that we've heard so much of flourished normalised and dominated. It was not a subculture among core groups or cliques. It was the dominant culture because, as Callum Tully and Owen Sirod explained, it was able to inculcate new staff members, was engendered through intimidation, bullying and fear, able to mould others and normalise complicity and the silence of others. The compelling evidence of Mr. Sirod on this topic and his experience when challenging racism is well known to the inquiry. It is key evidence underscoring the nature of the dominant culture of dehumanisation that was at play. It was evidenced in a number of different ways. The the widespread derogatory and abusive language normalised as everyday banter, despite its violence and debasing content. The use of racist language all illustrated the extent to which dehumanised attitudes and practices were embodied within the service culture, creating a context of impunity and providing the conditions for mistreatment, abuse and racism to thrive. As Professor Bosworth observed, when staff switched off from distress of detainees, this inevitably led to dehumanisation. The detainees themselves described how they were treated as less than human, as animals and criminals. Despite its gravity, self-harm was characterised as attention-seeking and manipulative, calculated to avoid removal and requiring a coercive response, not a trigger for review of detention and release. Healthcare was not immune to desensitisation and dehumanisation. Even their clinical training did not equip them to cope with the environment at Brook House. This was exemplified by the evidence of Jo Buss, who explained her response to the derogatory comments made by officers in the presence of D1527 in a state of acute vulnerability, that it simply washed over her like banter. You become immune. This indicates the extent to which there was a corrupted institutional culture, and one that there is no evidence has been fundamentally identified, addressed and rooted out. Finally, and in that context, there is the evidence of institutional racism. Professor Bosworth's view on that is clear, and she concludes that the seeds are sown in the very nature and function of immigration detention, just as Mr. Shaw had warned in 2005, that unchecked, IRCs are a breeding ground for racist and abusive word and deed. Evidence of pervasive racism was identified in G4S staff in the Mbenga inquest in 2003 and in Yarlswood undercover reporting in 2015. It is not new and it is ever present. This means that the inquiry needs to identify what measures were in place to address this critical issue in the institutional culture. It took forms of stereotyping as well as the overt racist language that the inquiry will be familiar with from officers like John Connolly, Graham Pennell and Sam Gurney, and which was said directly to the detainee D643. We say that when one considers the key factors identified by the Macpherson inquiry as hallmarks of institutional racism, they are all at play at Brook House. One critical factor that he identified is the failure of the organisation to unequivocally recognise, acknowledge and accept the problem. No official within the Home Office, no person within G4S has begun to identify and recognise the significance of the widespread evidence of racism. Anyone who maintains the idea of isolated individuals or the bad apple trope is only providing evidence to this inquiry that a key feature of institutional racism is still at play and operating amongst those responsible for this system. What then are the recommendations that the inquiry should make? the inquiry knows from our opening that the organisation Medical Justice, like the British Medical Association and many others, have called for an end to immigration detention. Professor Bosworth concurs. The evidence uncovered by this inquiry has only confirmed the validity and moral imperative of that view. Indeed, the current Chief Inspector of Borders has himself recently recommended that the Home Office undertake a proper evidence-based investigation into the need for immigration detention at all. The ICIB pointed to evidence that reporting to immigration officers is 95% effective and made other recommendations for compliance to be further improved. There is a viable policy alternative to detention, and policy questions are firmly within the terms of reference of this inquiry. If, and in any event, policies must operate effectively to constrain the exercise of this power and to prevent its exercise where the detained person is vulnerable, in particular by reason of a history of torture, trauma, and mental illness. Policy and statutory time limits already operate for pre-departure accommodation, as explained in the evidence of Ms. Ginn at paragraph 150. The family returns policy and the detention of children and pregnant women, other vulnerable groups, already have strict restrictions on the circumstances and the time for which a person can be detained. Those policies have brought to an end the extreme consequences of harm and suffering that are the hallmarks of the policy and context that we are considering. Again, we say this is not a radical proposition. It's where the evidence takes you. It's the conclusions of Mr. Shaw, the ICIB, the HMIP, the Home Affairs Select Committee, the Joint Committee on Human Rights, the British Medical Association, and many others. It was even the evidence of Dr. Uzarali that detention at Brook House should be no longer than a week. In the meantime, it is plain that there is a need for urgent measures to correct the complete deprivation of safeguards identified by Dr. Hard. Pre-detention screening has been repeatedly urged upon the Home Office by independent oversight bodies and NGOs like Medical Justice, and in this inquiry by Dr. Hard and Dr. Uzarali. It has shown to be effective in the context of family removals process, so that all factors such as medical conditions or vulnerability that point against detention are identified before detention takes place and avoids the harm occurring. Decisive urgent steps are required to address the wholesale failure to implement Rules 34 and 35 safeguards. As you pointed out, Chair, these are currently putting vulnerable individuals at risk of actual harm. Additional resources need to be urgently made available so that GP appointments within the first 24 hours are capable of fulfilling the Rule 35 and Rule 34 purpose. Rule 35 appointments need to be automatic and the delays must be eliminated. Opening an ACDT because of risk of harm should result in a Rule 35-2 report and consideration of a Rule 35-1 report, and if issued, lead to prompt release. Segregation due to self-harm and suicide risk should likewise trigger a Rule 35 report and release. This cannot wait until publication of the inquiry's report. It needs to happen urgently. Chair, you should consider interim findings and recommendations on Rule 34 and 35 and the adults at risk policy. We have seen a letter sent by the NHS and jointly with the Home Office, reminding healthcare professionals of the terms of Rule 35 and 34. We say that is woefully inadequate in light of the evidence that this inquiry has heard. We know that those healthcare professionals do not understand Rule 34 and 35, and critically, it is a question of resources. Nothing has come from the Home Office to indicate that they either understand or know or are willing to address the underlying problems that mean that those safeguards will continue to fail and individuals will continue to be at risk of serious harm. Detailed recommendations have been made on many topics of importance to this inquiry in the medical justice reports and in the position statements of the Royal College of Psychiatrists. We will expand on those in our written submissions, but commend them to you. Detailed submissions have also been made for suggestions to improve accountability of G4S corporate managers and Home Office officials. The culture of impunity must be addressed. Challenging institutional culture at all levels is a challenging task. It requires the kind of wide-ranging review and measures recommended by the Macpherson inquiry and adapted to the present context, again, in the witness statement of Ms Ginn on behalf of Medical Justice. Finally, this inquiry should conclude that Brook House must not be used as an IRC going forward. It should follow the conclusion of the HMIP that it is simply an inappropriate environment for administrative detainees, and the expert evidence of Professor Bosworth, which reflects the wider medical evidence, the accounts of G4S custody officers and senior staff, and of course the experience of those detained there. Last, we request this of the inquiry. This inquiry should have an implementation phase, as others such as the Lamming and Soham inquiry have done. It should reconvene to ascertain what has happened in the interim to implement its recommendations. This was raised in a letter to the inquiry as long ago as the 8th of November 2019 by my instructing solicitors at Duncan Lewis. Mr. Riley's evidence makes it all the more pressing because of the deferral of any action pending as a result of the Nationality and Borders Bill currently before Parliament. That bill will have wide-ranging implications for detention, not least the reintroduction of a detained fast track for asylum seekers, previously held to be unlawful and suspended precisely because of the failure of the safeguards of Rule 34 and 35 to identify those who are vulnerable. Professor Bosworth said, in this context, we go round and round in circles. She was correct. This inquiry must break the circle. It will be more effective in doing so if Home Office officials and its contractors understand that they will be effectively called to account for their action and, of course, inaction in response to this inquiry's findings and its recommendations. Those concentric circles should never again be allowed to lead back to the hell that was Brook House in 2017.
Thank you very much, Ms Harrison. This seems a convenient point to take our break, and then we will continue with the submissions. So we will return at 11:40. Thank you very much. Miss Morris, thank you.
Chair, I will address you now on behalf of Reverend Nathan Ward.
Thank you.
Reverend Ward had this to say at paragraph 14 of his first witness statement. Ultimately, however, after many years of trying to make change, I felt I just could not cope with continuing to work for G4S. I realised that by remaining in the system, I was perpetuating an unjust, inhumane system, which I would now describe as barbaric. Reverend Ward's perception of the system as unjust, inhumane and barbaric is exactly what the evidence in this inquiry has shown the system to be. In opening, on behalf of Reverend Ward, I provided a few examples of his experience of working for G4S at Gatwick IRCs. Those include unlawful uses of force, in other words, assaults, a culture of racism, institutional racism, including the use of cultural stereotypes and generalisations, and clear evidence of an us and them mentality. Furthermore, there was evidence of completely inadequate healthcare provision unsuited to the needs of the detained population. Reverend Ward described the assaults and abuse as shown on Panorama as a gross manifestation of an institutional and corrupt toxic culture. His views and experience of working for G4S, borne out by the evidence heard in this inquiry, is that the behaviour of staff was perpetuated by the system in which they were working. A system in which abuse could be meted out to detainees with impunity, in the absence of fear of consequences, due to silence and cover-up, directly caused by the culture of dehumanisation and othering. The toxic, masculine and bullish culture of which Reverend Ward spoke has been further illuminated by the other evidence that this inquiry has heard. Such a toxic culture even filtered down through to the training on use of force. Reverend Ward stated in his evidence that he had complained about the training on control and restraint more than anything else, as it was seen as central to the running of Brook House, which he viewed as wrong and which perpetuated a negative, macho-aggressive culture, which has been shown by the evidence that this inquiry has heard to have been pervasive across Brook House. Reverend Ward's resignation was in 2014, and yet the inquiry has heard evidence of the exact same or similar issues continuing at Brook House during the relevant period. Therefore, the evidence shows no improvement between 2014 and 2017, notwithstanding two things. First, the abuses at Medway STC being exposed in the intervening period, and the Medway Improvement Board highlighting serious issues with leadership, organisational behaviours and culture as causal of the issues at Medway STC in its advice to the Secretary of State for Justice. Second, Reverend Ward's own whistleblowing, as set out in his first statement, and just to name a few names of people and organisations he raised concerns with, he raised concerns with Duncan Partridge, Ben Saunders, Deborah Weston, Steph Phillips, Jerry Peverick, Kent Police and the Home Affairs Select Committee. So since 2017 and to the present day, at best, there's been some tweaking around the edges. At worst, the very same fundamental issues as were occurring prior to 2017, in Reverend Ward's experience, are continuing to this day at Brook House, and not just Brook House, in other parts of the immigration detention estate. And there is no sign of any real or substantial change. By way of reminder, it is the lack of accountability and sanctions to date that was Reverend Ward's primary reason for participating in the inquiry and why he considers it important. So I'll come back to what he said in his first statement at paragraphs 309 and 310, as quoted in opening. He said, "I strongly believe that things will not fundamentally change unless people are held to account at all levels of the system and serious consequences occur for the individuals and the corporate bodies. I do not understand how G4S could continue being the contract provider for almost 3 years after the Panorama broadcast, which included a 2-year extension. And equally, why any contract could continue to be run with G4S after the Medway and Brook House reporting. I also do not understand how managers within G4S with oversight for these centres or on site like Ben Saunders, Steve Skitt, Jules Williams or Steve Dix were not dismissed, but were able to continue in their roles or take up posts elsewhere. I also do not understand how senior civil servants responsible for these contracts, such as Paul Gasson or Mr. Schoenberger, and for detention services generally, have not been disciplined but remained in post. Until concerted action is taken and is seen to be taken, complaints made will be ignored or more likely won't be made at all because people will have no confidence in the system." Reverend Ward asked this question: how then can you, Chair, be confident that any further tweaks will lead to the real and significant change that is required? He says you can have no confidence whatsoever, as history and the evidence has shown that minor tweaks don't stop mistreatment and abuse, and they don't change the toxic culture. Reverend Ward says that the changes that are required involve a dismantling of the whole immigration detention system. His view is that to do anything less than the significant changes that are required will allow the corrupt and toxic institutional culture of abuse, bullying, disrespect and dehumanisation, as it was in 2017, and indeed 2014 and prior to that, the system that Reverend Ward had no choice but to leave to continue. Such a barbaric system has no place in our society, and Reverend Ward hopes that the outcome of this inquiry is swift and systemic change for the sake of humanity. Thank you for listening.
Thank you very much, Ms Morris. Mr Goodman.
Chair, on behalf of D1527, D1538, D2077 and D1914, may I thank you, Chair, and all the inquiry team for the work that's gone into the investigation of mistreatment in Brook House. I begin with D1527's case. Before this inquiry started, the Professional Standards Unit had already found in its report of the 22nd of February 2018 that D1527 was degraded, reflecting the language of degrading treatment in Article 3 ECHR, and had made a number of findings that amounted to inhuman treatment, see CJS 01107. It's abundantly clear on the evidence that he was subjected to inhuman and degrading treatment, as well as to procedural breaches of Article 3. Those breaches are intrinsically connected to the failure of the law, policy and operational safeguards which should have ensured that as a vulnerable young man he was not detained at all, or that he was released expeditiously once wrongly detained, or that he was cared for while in detention. D1527's case has always been that there was both a systemic and operational failure to identify, protect and monitor him as a vulnerable detainee in breach of the positive duties arising from Article 3, see HA Nigeria against Secretary of State for the Home Department 2012, EWHC 979 admin at paragraph 70F, and that he was detained without ensuring his mental health, history of torture and suicidality were properly assessed and considered. Such measures as were in place were not used effectively to diagnose and properly treat and manage his condition, see MD against Secretary of State for the Home Department 2014, EWHC 2249 admin at 142. These aspects of his detention will all be addressed further in written submissions. In the short time available for this oral submission, I propose only to outline why the ill treatment he endured amounted to torture. Paragraph 20 of CTI's note to the inquiry, which we heard orally from Mr. Altman earlier, says that in order to make a finding of torture, there must be deliberate inhuman treatment causing very serious and cruel suffering. That is accepted. However, the gloss at paragraph 21 of the note, that torture involves a very high degree of physical suffering, is too narrow. Acts causing severe mental suffering that cause no physical injury can amount to torture. See Ireland against the UK, 2018, 67 EHRR SE1 and El Masri and Macedonia, 2013, 57 EHRR 25, paragraph 202. A fortiori, where the mistreatment involves both physical and mental suffering, it can amount to torture. Ascertaining whether D1527 has been tortured, in line with the definition in the Torture Convention, as to which see my opening statement, involves asking the following 6 questions. Firstly, should you, Chair, consider each individual act of abuse in isolation to determine whether each individual act amounts to torture, or should you consider the combination of abuse over the whole 10-week detention? I shall explain why it's the combination. Was the pain and suffering inflicted intentionally? Was there infliction of severe pain or suffering, physical and or mental? Fourth, was pain or suffering inflicted for the purpose of intimidating or coercing him, or was it based on discrimination of any kind? Fifth, was pain or suffering inflicted by a public official? And sixth, was the pain or suffering inherent in or incidental to a lawful sanction? So taking the first question, should the Chair treat the acts in isolation or as a whole? Assessing whether a detainee was subject to torture or indeed inhuman and degrading treatment involves assessing the treatment in detention as a whole over the full 10 weeks of D1527's detention. Whether treatment amounted to torture cannot be properly answered on consideration of a series of discrete acts artificially dislocated from one another and likely to omit consideration of the cumulative effects. This approach, which I commend to the inquiry, is supported by legal authority. In Selmouni v France, 2029 EHRR 403, the allegation was of torture in circumstances in which Mr. Selmouni was subject to a series of assaults and victimised in a series of bullying acts by police, see paragraph 103. At 104, the European Court noted that the events were not confined to any one period of police custody, and it held at 105, the Court is satisfied that the physical and mental violence considered as a whole committed against the applicant's person caused severe pain and suffering and was particularly serious and cruel. Such conduct must be regarded as acts of torture for the purposes of Article 3 of the Convention. Similarly, in Ireland against the UK 2018 67 EHRR SE1, the European Court considered whether 5 disorientation techniques used in Northern Ireland in interrogations consisting of wall standing, hooding, exposure to noise, sleep deprivation and deprivation of food and drink amounted to torture. The Commission's opinion is recorded at paragraph 133 of the Court's determination as being that considered separately, acts such as sleep deprivation or restrictions on diet might not as such be regarded as treatment contravening Article 3, but that in combination, the practices amounted to a breach of Article 3. The Court conducted its inquiry on the basis of the in-combination effects and the overall impact of being detained. Consideration of in-combination impacts can also be seen in the Court's assessment of the 3-day extraordinary rendition in Haj Rulahu against Macedonia, 2018. That said, Chair, turning to 1527's case, 1527 does invite you to determine that the incidents on the 25th of April 2017 and on the 4th of May amounted to torture even when taken in isolation. Professor Katona's evidence in his first statement, which is BHM 000030 paragraph 50, is that on viewing the strangulation incident involving D1527, the mistreatment and threat to kill appears to have had a profound emotional reaction and psychological consequences for D1527 that induced an intensity of suffering sufficient from the footage of it to cross the very high threshold to constitute torture. And he goes on to explain factors relevant from the Istanbul Protocol, to which I refer tribunal, the inquiry. These observations can also be read across to the incident on the 4th of May. However, if contrary to D1527's primary position, you, Chair, consider that taken alone those incidents of mistreatment do not amount to torture, it then falls to be considered whether the in-combination effects of the whole detention amount to torture, just as in the cases of Ireland, Selmouni and Els Masri I've cited. D1527's experience of torture involved a combination of both acts of deliberate violent physical mistreatment and deliberate psychological abuse on the one hand, but also non-intentional factors, including being falsely imprisoned, the conditions of detention, the failure to manage his mental illness and vulnerability, his self-harm, food and fluid refusal, his suicidality. And those factors set the context for and aggravate the severity of the individual acts of deliberate violence. So the second question: was there an act or acts which were intentionally inflicted? The primary act in question is the detention as a whole. The detention as a whole was undoubtedly a deliberate act by the state, and the simple answer to the first question posed by the definition of torture is yes, the detention was intentionally inflicted. There were also a series of deliberate acts within that detention. There were at least 3 deliberate acts of unlawful physical violence against him, on the 24th of April, the 25th of April and the 4th of May. As the Professional Standards Unit found, the 24th of April incident degraded him. While he was on constant watch, his head was banged against a table by DCO Sanders, who later brags about the incident. The following day, again, as found by the PSU on the 25th of April, the use of force filmed by Mr. Tully involving him, Mr. Pascali, Clayton Fraser, Charlie Francis and Joe Buss breached Article 3. The so-called chokehold was evidently intentional, and that has never been denied. Indeed, it was accompanied by threats such as, "I'm going to put you to sleep, you fucking piece of shit," and other insults by onlookers such as, "Are you a man or a mouse?" mocking him for being a child or a baby, in Nathan Ring's case. Mr. Pascali described his use of the chokehold as a response to being frustrated by D1527's behaviour. Even the concocted explanation by Mr. Pascali that he was seeking to gain compliance is itself an admission of intentionally using an unauthorised restraint technique. There's no doubt the acts were intentional. Mr. Collier's view was properly that Mr. Pascali's actions were deliberate. The experience was then followed by maintaining him unlawfully and deliberately in isolation. And then on the 4th of May, D1527 endured a psychotic episode on the suicide netting, in which he was mocked and taunted by officers and detainees alike. Half an hour later, he had calmed down, and DCM Dix came to the room with several other DCOs. The records show, at CS 001026, that the intention was a clearly premeditated one to remove him from association and was clearly unlawful. I spoke to D1527 about his behaviour and the consequences of his actions, says Mr. Dix at HOM 000251. In the terms of the URF report, use of force report CJS 005530, upon arrival, I saw detainee D1527 on the first floor netting. I explained, due to his behaviour, he would need to comply and go to the CSU on Rule 40. He said no. I explained if he refused, then potentially as a consequence of his actions, force could be used. And again, in oral evidence, Mr. Dix's evidence was, at the time, obviously, when someone is on the netting, then obviously the procedure was to get them to go to Rule 40. I'm not sure if it was a policy. It was, due to the fact of the level of disruption caused on the netting and the wing. The process of physically removing him to E-wing involved significant levels of violence, and it was obviously deliberate. On arrival at E-wing, D1527 was then subjected to further deliberate mistreatment, a full strip search, which in and of itself breached G4S policy, which reserves it for cases of intelligence a detainee is hiding an illicit item. The body-worn camera footage, URF 114.17, captures the footage at the point he's been relocated to E-wing. And we hear, again, DCM Dix stating, when we leave the room, someone's going to watch you, okay? If we leave this room and you start self-harming like you've done before, and obviously like you do, then obviously your behaviour dictates what happens in your future, okay? No one wants that, okay? If you stay calm, but I told you, the way you've gone about things, jumping on the netting is not the right way, so you should have spoken to a manager. But your problem is that you go from okay to lose the plot in 2 or 3 seconds, and that's what's landed you in trouble. He then asks for D1527's trousers, says he'll give them back later, and on the footage we see officers guiding him downstairs cuffed. Again, an officer says, you'll do what I tell you to do, okay? And when we let go of everything, okay, if you start to do what you did last time, self-harming, constant, then obviously your behaviour will dictate how long you stay there for. Makes sense. There's no doubt that this outlawry on the 4th of May, under the guise of Rule 40, was planned and intentional. Mr. Dix admitted as much in his written report and oral evidence. The footage confirms the intention is to punish or impose some perverted sense of discipline on him for his self-harming activities. He was subject to deliberate use of removal from association. It's apparent from the Home Office correspondence of 28th of March 2022, that's HOM 03326161, and G4S correspondence of 22nd of March, CJS 00741121, that this was also unlawful. D1527 was the subject of numerous recorded deliberate insults, mocking and humiliation, names, verbal abuse. They don't need to be explored or further repeated. He was subject to deliberate psychological torment, Mr. Dix telling him the extent of time in isolation depending on his behaviour, Nurse Karen Churcher tormenting him by telling him he was being detained longer because he was self-harming, racist insults and denial of religious rights, deliberate acts of concealment of the events in the paperwork. Looking then at the question whether this caused severe pain or suffering, physical or mental, this question is assessed on a relative basis. It depends on the circumstances, the age of them and the mental health of the victim, see Ireland and UK, paragraph 162. The effect here, for your consideration, Chair, is the accumulation of suffering in making an assessment whether it meets the severe threshold. That's critical. For example, D1527 does not suggest that taken in isolation the events of the 21st of April or the events of 24th of April amount to torture, albeit they amount to the inhuman and degrading treatment. On 24th of April, he attempted suicide using a ligature. He was removed from association without proper legal authority, put on constant watch where his head was banged against a table by the officer responsible for constant watch. As Dr. Hard explained in the evidence, being put in isolation would then have exacerbated and increased any detainee's thoughts of self-harm and suicide, particularly where accompanied by abuse of this kind. While all of that which happened amounted, taken alone, to inhuman treatment, it's accepted it doesn't amount to torture. But those experiences on the 24th of April, and earlier on the 21st when he's told his own self-harm is prolonging his detention, an experience which led to him attempting suicide that day, are highly relevant to assessing whether his treatment in combination amounted to torture. The suicide attempts he made on the 25th of April were not some random isolated event. They followed at least 2 preceding suicide attempts and were triggered by and consequent upon the Ewing isolation, which had exacerbated his suicidality. On this day, the same pattern followed: further verbal abuse, extreme physical abuse, further humiliation and isolation in Ewing, and further exacerbating his suicidality and sense of powerlessness. His only recourse at this point was food refusal, which he deployed. So by the 4th of May, we see the punishment for jumping on the netting for his behaviour. In this context, he is then violently removed into isolation. The 4th of May was enacted then as a living flashback, a reiteration and repeat of the abuse of previous weeks. It could not have been better designed to terrorise him, to exacerbate his suicidality, self-harm, and what by then had been diagnosed as his PTSD. The repeated nature and duration of the psychological terrorisation cannot be ignored in assessing the severity of the impact on D1527 and whether it amounted to torture. Indeed, on the late disclosed footage, Mr. Dix is heard to say that D1527 is taken to Ewing, that obviously your behaviour will dictate how long you stay here for. Makes sense? It's impossible not to hear the echo of the double bind Karen Church had imposed on him 2 weeks earlier in telling him his own self-harm would cause him to be detained longer. The cycle of despair where self-harm occasions abuse, that occasions more self-harm, was both tortuous and torturous. In assessing the severity of harm and whether it amounts to torture, the inquiry looks to the subjective experience, and that involves looking at the totality of the treatment. The inquiry must also have regard to what happened after the 4th of May and the following 5 weeks. In Dr. Thomas's report on the 21st of May, she described by that point he was attempting suicide near daily with a high likelihood of success, HOM 002997. He continued to refuse food, his sense of powerless multiplied, and when confronted with evidence, the Home Office refused to release him. Fourth question, was the mistreatment inflicted for the purpose of intimidating or coercing him, or was it based on any discrimination? The unlawful detention was designed to coerce him to leave the country. The acts of violence once detained were inflicted to intimidate or coerce D1527. The use of the threat, "I'm going to fucking put you to sleep," was designed to intimidate him. The intimidatory impact we've seen, induces a panic attack on the footage. Mr. Pasquale's own defence, that he adopted the chokehold to gain compliance, is, even on his own account, intimidatory. And indeed, coercive. Similarly, as set out already, the use of removal from association on the 4th of May can be seen to be riddled with language of officers, particularly DCM Dix, setting up their own ad hoc laws, which he was told he must comply with. All of these threats and exertions of force were evidently being used as forms of coercion and intimidation. Fifth was the treatment inflicted by public officials. There's no issue about that. All of the wrongs were from Home Office, medical and G4S officials. Sixth, was the pain and suffering inherent or incidental to a lawful sanction? No. The evidence is clear there was no lawful sanction for any of this. D1527 was not lawfully detained. He should not have been there. Once detained, he should have been released within most 48 hours pursuant to the proper operation of Rules 34 and 35. The complete failure of that system meant he was not. The inquiry doesn't have to speculate on that because the High Court came to the view he should be released on the 13th of June, even on the limited information available to it. There was no authority for the trespasses to the person while he was detained. The Rule 40 removal from associations, is quite clear, were all not properly authorised at the right level and not for purposes within the ambit of Rules 40 or 42. The correspondence from the Home Office clarifies the only people who could authorise Rule 40 were Paul Gasson, as delegate of the Secretary of State or the manager Ben Saunders, arguably after the 18th of July, after D1527 left detention, when the DSO came into force, there were other delegates in cases of urgency, but not relevant to his case. Dr. Hard was in any event of the view that, quite apart from the lack of personal authority, the routine use of Rule 40 for purposes which were not legitimate was evident across the evidence base to the inquiry. The pain-inducing techniques were clearly not lawful, as Mr. Collier said in evidence in relation to the 4th of May. So in conclusion, for these reasons, Chair, you are invited to find that the individual incidents and the treatment as a whole met the severity and the conditions for a finding that D1527 was tortured. Almost all of what happened to D1527 could and would have been avoided if the legal requirements of Rules 34 and 35 or the adults at risk policy had been observed. There's an urgent need to address these system failures, as there is on Rule 40, where Mr. Dix, a chief protagonist in the misuse of that rule, remains in position with greater authority. And as he and Steve Hewer both confirmed, defiance of the law continues in that regard too. D1527 therefore emphasises the following requests. Firstly, the interim recommendations are made urgently. There are people in detention now subject to the same system failures and neglect to which the core participants in this inquiry were subject. On this, which is in fact the 5th anniversary of D1527's detention in Brook House, there's been no direct apology, no compensation, no formal recognition of wrongdoing by any wrongdoer to him. You're asked, Chair, to recommend the Secretary of State personally apologise to him. That might offer some form of psychological restorative. And lastly, you're asked to acknowledge that D1527 is not a piece of shit, but a human being entitled to dignity as such. That he was subject to torture is a stigma which should lie against the Home Department as a spur for reform. I turn next to D2077. His submissions will be taken shortly for current purposes. You'll recall, Chair, he's a recognised refugee from Iran who fled after multiple incidents of torture related to his Christianity. He suffers from PTSD and has a serious history of self-harm. The key feature of his case is that he had been detained at Tinsley House in 2016, where a Rule 35(3) report confirmed he had mental and physical symptoms consistent with an account of torture, including being whipped in detention in Iran, and it was recorded he was suffering flashbacks in detention, and as a consequence, on the 21st of June, the Home Office agreed to release him. In November 2016, he attempted suicide, partly as a result of his fear of being detained. He was marked as level 3 in the adults at risk policy within internal Home Office documentation. But in February 2017, his proposed detention, was in fact rejected by the detention gatekeeper on grounds that there was no removal directions and he was a safeguarding level 3 case. However, shortly after this, the Home Office arranged a charter flight and decided to recategorise his status under the adults at risk policy as level 2, so as to allow him to be detained prior to the charter flight. He ended up cuffed in a van, transported to Brook House on the 6th of April. A familiar pattern of the failure of the Rule 35 process ensued. D2077 began refusing to eat, in this case by way of hunger strike, before shortly afterwards sewing his lips together. This then entailed his removal from association for 5 days. No Rule 35 assessment followed. After much work by his lawyers and the intervention of a medical report from Medical Justice Doctor, he was released on the 21st of April. His is a case in which, following the first detention, he had been identified as a torture victim and as level 3. There is a glimpse here of how a system of screening vulnerable detainees could operate so as to prevent the heinous detention of vulnerable people. However, when the imperative to remove him pressed, the integrity of the adults at risk policy and the system around it was compromised. And in truth, this is another case of how the mere existence of policies and rules is no guarantee the Home Department will comply with the law. D2077 asked the inquiry find there was a clear breach of the procedural rules, procedural duties to anticipate and safeguard against Article 3 mistreatment. This is a case in which the system failures led to an horrendous experience in detention of a vulnerable torture victim who should never have been detained. it was inhuman and degrading treatment, and the inquiry is asked to so find. Turn next to D1538. D1538 was detained at Brook House during the relevant period on two separate occasions, 1st of June 2017 to 14th of June 2017, and again 27th of June to the 15th of July 2017. No adequate Rule 34 process, no Rule 35 assessment undertaken at Brook House, despite him asking for one. See DL000231, page 37. A report was undertaken later at Harmondsworth, which led to an assessment that he was a level 2 adult at risk, CJS 07299. D1538 found the environment and general conditions at Brook House to be very stressful and humiliating. In his evidence to the inquiry, he emphasised the prolonged lock-ins, the lack of adequate medical attention, the lack of privacy when using the toilet, the cramped, smelly, noisy conditions which he found very scary. He found the inability to communicate with an interpreter stressful, and there were delays in accessing legal advice. The impact of the detention on him was to leave him in constant state of not knowing and uncertainty, in his words. He said he did not know when he was leaving or if he was leaving and where he would be going. He says Brook House is like a forgotten prison with forgotten prisoners. Against this background, D1538 experienced, firstly, unlawful use of force and assault on the 3rd of June when DCO Instone Brewer unreasonably denied 1538 the use of a computer and instigated a verbal altercation with him. DCO Fiddy intervened, dangerously pushing 1538 twice in the area of his neck and head, not an approved technique. Second, D1538 was then, as a punishment, transferred to segregation without authorisation from the Home Office and without justification in breach of Rule 40. Third, on 6th of June 2017, D1538 was attacked by another detainee, D197. DCO Ryan Bromley and DCM Nick London restrained D1538, and then DCM Steve Farrell grabbed D1538's head and neck. Footage shows the use of force was unlawful. All three officers provided inaccurate use of force forms and dishonestly claimed the restraint was to prevent 1538 from hitting his head on nearby cabinets. DCO Bromley said to Callum Tully 4 days after the incident that DCM Farrell had taken D1538's head clean off, referring to the grab of his head and neck. 1538 was again taken to E-Wing to cool off, which amounted to unlawful de facto segregation, not authorised under Rule 40. On the 28th of June 2017, Darren Tomsett said to 1538 he looked gay. D1538 was fearful of the reaction of others and was proven right when other detainees mocked him for days afterwards. On the 4th of July 2017, he witnessed his cellmate D865 attempt to kill himself by tying a ligature and hanging it from a TV bracket. He was scared and traumatised by this experience, which has had a lasting impact on him. The breach of Article 3 duty in this case, firstly the systems duty. He was exposed to mistreatment by reason of systemic failures and the corrupt and toxic institutional culture of abuse. And of the operational duty, D1538 was subject to assaults, homophobic abuse, witnessed a highly distressing and traumatising incident of attempted suicide. Staff were callous and negligent and indifferent to the suffering of his suicidal cellmate or his own trauma. He was subjected to 2 episodes of unlawful segregation imposed without authorisation and as punishment. Individually and cumulatively, the incidents of physical and verbal abuse, as well as the impact of conditions at Brook House, the lack of adequate care, caused him pain, suffering, anguish, distress and trauma over and above that which is incidental to lawful detention and breached Article 3. He also relies on a breach of the investigative duty in the inaccurate and dishonest reporting of these incidents and the failure to investigate. And then finally, Chair, on D1914, you will recall he's a Romanian national who was detained for 4 months in Brook House Immigration Removal Centre. You are asked to find that as a whole, his detention in Brook House constituted inhuman treatment or degrading treatment. Alternatively, that various incidents amounted to such treatment, and that in his case too, procedural duties to anticipate and obviate such treatment were breached, as were investigative duties thereafter. D14 should never have 1914, should never have been detained. He had won an appeal against extradition on the basis of his Article 8 rights. He's an EU national with a wife and child in the UK. Yet in defiance of that finding, the Home Office detained him on the 30th of March, 12 days prior to even making a further deportation order, served on the 11th of April. After many horrors, the Home Office appeared before the Immigration Tribunal, unable to offer any explanation as to why, on the appeal against the deportation order to D1914's, the approach to Article 8 family life rights should be any different to that taken by the Divisional Court of the High Court in relation to extradition. So his case is another one where administratively the detention was a pointless exercise, serving not to achieve any end related to immigration control other than to deform a man's life. Once detained, he should have been released on medical grounds. He was not. The Home Office record of the decision to detain him described the pains in his chest, which were in fact associated with a serious heart condition, as feigned illness. That he was 3 times hospitalised whilst in detention and was awaiting a heart operation spoke otherwise, albeit not to the Home Office's ears. In his case, the Home Office wrote to the detention centre doctor, Dr. Chowdhury, shortly after he was detained, asking for that doctor to confirm he was fit to be detained and fit to fly. In a breach of patient confidentiality, the doctor, without authority from the patient, informed the Home Office he was indeed fit for both. And on the 12th of April, Dr. Uzerali also asserted he was fit to fly and be detained. He remained in detention. On the 27th of May 2021, Dr. Uzerali again compromised medical ethics and deemed that D1914 was fit to fly and to be detained, adding this time that he was happy for control and restraint to be used. This time, that brief note had a crucial bearing because it has been seen in footage and other evidence that officers regarded this as a medical disclaimer, meaning to one DCO, if he dies, he dies. It was a licence to use inappropriate force against a man with a serious heart condition. On that day, he was subjected to a fully kitted use of force, orchestrated again by Steve Dix, pursuant to a blatant misuse of Rule 40, to secure his translocation to E-Wing prior to removal the following day. Not only was there no proper authority for this removal from association, in that it was not authorised by the Secretary of State, it was also not for a purpose legitimised by Rule 40 itself. The severity of the psychological impact of the unlawful violence against him is expressed at paragraph 151 of his statement. It felt like they were climbing all over me, on my arms, my back, on my head. I was shouting and howling in pain. I was struggling to breathe. I thought I might be dying. The pain in my chest was very severe. At that moment, I felt I was looking at death. He was taken in handcuffs to E-Wing, half naked and groaning from his medical conditions. There he was duly humiliated by a strip search and made to sit in plastic pants. He recalls that he felt like he would rather die than go on like this. Mr. Collier gave evidence as to the dangerous practices deployed in the use of the shields on this occasion, the techniques being deployed including a risk of fatality. Having viewed the CCTV footage, Mr. Collier decried the fact that he was undressed in the removal from association, concluded that handcuffs and PPE were unnecessary as there was no physical threat to staff. The evidence of Dr. Hard as to the impact of isolation being to worsen the feelings of self-harm and suicidality is expressed clearly in this unlawful and unnecessary use of isolation by the outlaws that operated as officers in Brook House. As it transpired, he was not removed from the UK on the 28th of May, a sensible pilot apparently standing between the Home Office and its attempts to cause further harm to D1914. On his return to detention, his wrists bruised from handcuffs, the DCOs were incensed. Some of the footage we have seen shows officers referring to him by racist epithets such as traveller. Dan Luke stigmatises him on the basis of a misunderstanding of his criminal record, saying he doesn't rape kids, he kills them. He was hospitalised 3 times for his heart condition while in detention. On the 5th of July, he was refused bail, and he describes at paragraph 190 of his witness statement that at that point he no longer wanted to live. And although never having tried to harm himself before, he attempted to take his own life, taking 57 tablets and cutting himself with a razor. DCO Tully described the shocking amount of blood in his cell. Both Dr. Chowdhury and Dr. Uzerali sought to defend the medical ethics of disclosing his medical data, but there is no justification for their conduct. It led directly to dangerous and unlawful physical abuse on the 27th of May. His case also exhibits the dangerous practice about which both doctors openly boasted, of replacing the Rule 35 system mandated by law for which official channels are designed, with their own system of sending Part C forms to a different branch of the Home Office. In his case, Part Cs were issued on the 11th of April, 19th of April, 27th of May, 28th of May, 3rd of June, 5th of July, 6th of July, 7th of July, and 13th of July, when he belatedly and finally managed to obtain a Rule 35 appointment on the 17th of July, nearly 3 months after being detained. Dr. Uzur Ali finally completed a Rule 35 report, and although it still took a fairly long time to process, it was that document which led to his release just in time for his heart operation in August. In D1914's case, he was subjected to inhuman treatment over the course of detention and to degrading treatment over the course of detention, whose severity is marked by the impact it had in rendering him suicidal. Indeed, he very nearly managed to kill himself as a direct result, not of being detained, but of being falsely imprisoned. Then, as a result of the breakdown of systems designed to protect vulnerable detainees from detention, of not being released. He describes how Brook House has had a lasting impact on his mental health, that he continues to feel low. Particular factors in his mistreatment were the unlawful decision-making by the Home Office in detaining him, the absence of any screening mechanism to ensure relevant factors were taken into account about his health, and indeed immigration position before or during detaining him, the medical practices of Dr. Chowdhury and Dr. Uzur Ali in deeming him fit to be detained and fit to fly and fit to be subject to force, failing to comply with their duties under Rules 34 and 35, the routine unlawful use of removal from association by officers, particularly Steve Dix, who neither enjoyed authority for such matters nor used it for lawful purposes, and the absence of any monitoring or checks and balances capable of picking up on the rampant outlawry exhibited in this case. The inquiry is invited to find he was subjected to inhuman and degrading treatment both within the individual incidents and in his overall detention. There was a procedural, systemic and operational failure to identify, protect and monitor D1914 as a vulnerable detainee in breach of the duties arising under Article 3. Thank you.
Thank you very much, Mr. Goodman. Mr. Lee.
Thank you, Chair. I shall be addressing you in closing concerning D643. Before I begin, just on behalf of D643, I'd like to thank you, Chair, Counsel and solicitors of the inquiry legal team and all of the support staff for bringing this inquiry together with such care and such hard work. I'll address you slightly later on about what it meant to D643 to be able to come and give live evidence to the inquiry. D643 spent a total of 558 days in Brook House over the course of 4 separate occasions. On the 4th occasion, he was detained for 504 consecutive days. He was detained in Brook House for the entire relevant period that the inquiry is concerned of, and for substantial periods before and after it. He was never removed. He remains in the UK, and he was paid substantial damages by the Home Office in respect of his unlawful detention in Brook House. No one has ever apologised to him. 503 consecutive days in administrative detention is a scarcely believable amount of time. In and of itself, Chair, you may consider that it shows that something very badly went wrong with D643's case. For context, this is the 45th day that this inquiry has sat. It's 131 days since phase 1 of the inquiry started back in November of last year. That in itself seems a long time ago. You heard live evidence, Chair, that D643 served in the British Army in Kosovo, Bosnia and Iraq, and first began to experience the symptoms of post-traumatic stress disorder, PTSD, in 2007, after returning from service in Iraq where he'd seen friends and colleagues die in horrendous circumstances. He made an attempt on his life in 2011 and spent 3 weeks in hospital before being discharged from the army in 2012. You also heard he was awarded compensation from the Ministry of Defence as a result of the debilitating effects of his PTSD. D643's case is in many respects the embodiment of all of the systemic failings in Brook House that this inquiry has heard about. Just a few examples. He suffered racist abuse from officers, including when he was so ill from food poisoning that he had passed out in his cell, being woken to hear Graham Pennell, a G4S officer, say to him, "Why don't you go home, you fucking nigger? Why are you pretending that you are sick?" He was mocked by other officers, including DCMs, Andrew Lydon and Steve Webb, who told him he was pretending to be sick to avoid his removal from the country. On other occasions, he heard an officer say, "Why don't these blacks go back to their country?" And "All the blacks are the same." He describes a culture of disbelief from both guards and healthcare, a description wholly consistent with other evidence that's emerged during this inquiry and that you, Chair, have seen and heard. He describes officers mocking and laughing at detainees who were mentally unwell, watching detainees in states of distress and laughing at them. Again, this is wholly consistent with footage that's been examined and other accounts of the toxic culture at Brook House. He described officers stating that detainees were pretending to be ill to avoid deportation when in fact they were in profound mental health distress. He also describes a culture of complacency and indifference towards bullying and abuse from other detainees, how he would be subject to homophobic and racist abuse, but guards would do nothing to intervene and sometimes even join in. He was subject to disproportionate use of force on at least 2 occasions. He was subjected to a Rule 40 removal from association that was clearly illegal, and he describes other more routine, more mundane and petty cruelties, such as being refused toilet roll and other essential items. Having posts pushed under the cell door in the dead of night so that men would wake up to see it and fret that it was bad news about a removal flight or a decision on their immigration status. He talked of the frustration of men not being able to contact their lawyers because of poor internet connection and other inadequate communication facilities. But, Chair, it was his treatment by healthcare staff that has had the deepest impact on him and that is, on any analysis, deeply shocking. In context, in many respects, D643 had huge advantages over many of the other detainees. He's an articulate man. He spent 11 years in the British Army. He speaks fluent English and understands how to operate in a hierarchical, structured and process-driven environment. He'd experienced detention in other IRCs and in prison, and he'd even been tasked by the British Army to assist with the detention of people in Iraq. Despite all of this, he experienced catastrophic failures of care at every turn, beginning with the failures by the doctors to give him a proper physical and mental health examination on entry, failures to take the most basic of steps to check his previous medical records when he was inducted, and a complete failure to identify, diagnose, and to attempt to treat his mental health problems, including his complex combat-related PTSD. D643 was a man who liked to keep notes, to write things down, to keep a record. He diligently tried to follow the correct procedures. He made complaint after complaint after complaint about his treatment and the lack of engagement by healthcare staff. Those complaints either disappeared into the ether or took so long to be considered as to be entirely useless. It must have been like shouting into a void. You've heard that when D643 entered Brook House on that 4th occasion, despite having had 3 previous health inductions and having been diagnosed with PTSD while he was in the army, subsequently whilst in prison, and in another IRC, there was simply no mention of PTSD in his health screening records. And despite having informed Brook House Healthcare on previous documented occasions when he was there about this diagnosis and of the previous treatment he needed and had received, and having just 2 weeks previously, prior to his induction, having had a Rule 35-1 report issued at the Verne on the basis of his PTSD, there was no mention of that diagnosis, the Rule 35-1 report, or the medico-legal report that triggered it in his medical record upon entry to Brook House on the 21st of December 2016. That careless, indifferent cruelty was to become the theme of his lengthy detention at Brook House. It was a shocking failure from the outset to comply with Rule 34 and Rule 35 of the detention centre rules. It was a shocking breach of the duty of care to a vulnerable detainee. Chair, Rules 34 and 35 of the detention centre rules have been on the books for over 20 years. It is simply unbelievable that those in charge of healthcare at Brook House did not apply them properly. They are not, despite what some corporate witnesses have said, complicated. They amount to a few sentences. They are the rules. To fail to apply one of the few safeguards that vulnerable detainees had to protect them is inexcusable and unforgivable. And let's not forget that the Home Office watched with folded arms as month after month, year after year passed and no Rule 35.2 reports were issued and barely any Rule 35.1 reports came through. Did this not pique anyone's curiosity as what might be happening? Apparently not. Sandra Carver and Dr. Uzer Ali gave evidence that the Home Office never once raised any concerns about the lack of those Rule 35 reports. Why? I think we know the answer. Dr. Hard gave evidence that the treatment or lack of it of D643 indicated both a systemic failure in the screening process and the application of the Rule 34 and 35 processes, and was indicative, he accepted, of a lack of a system to identify and cross-refer to previous medical history. Dr. Hard also agreed that if someone like D643, who, as I said, spoke fluent English, who was articulate, who was able to identify precisely what he required to treat his PTSD, having received that treatment before, if he could not obtain the treatment he required, it would be practically impossible for someone who did not share those advantages to get adequate treatment. It's worth pausing to think what that means. It means it's likely that hundreds of detainees during the relevant period and before and after, whose names we will never know, whose stories will never be told, suffered in similar ways. To suggest that what we've seen in this inquiry amounts to a series of isolated incidents is, with the greatest respect, utter nonsense. D643 describes being particularly upset at the callous indifference of Doctors Chowdhury and Uzer Ali. Callous indifference, you may find, Chair, that is wholly corroborated by the evidence that you've seen in this inquiry. The examples are many, but I shall mention, because of the time restraints, just 4. On the 12th of June 2017, Dr. Chowdhury confirmed to the Home Office in a letter that D643 was fit to be detained and fit to fly, and that was despite not examining D643, not referring to any of his mental health difficulties, and not having even seen him for 3 months. No doubt the good doctor was just giving the customer, the Home Office, what he knew they wanted. In July 2017, D643 tried to give healthcare 3 separate medico-legal reports by acknowledged experts, commissioned by his solicitors, that confirmed he was not fit for detention. The doctors refused to look at them. Pausing there, it's of course not enough simply to point the finger at the 2 careless doctors. Those medical reports were provided to the Home Office, yet detention review after detention review kept authorising detention. In January 2018, D643 tried to tell Dr. Chowdhury that he was suicidal and needed help, but was turned away and told he could not help him. Of course, it goes without saying that no Rule 35.2 report was even contemplated. In February 2018, D643 went to Dr. Uzari again and attempted to get help on the basis that his mental health was deteriorating. Again, no help was proffered, and D643 was told that the doctor had no time to waste on him. Again, it goes without saying that no Rule 35 report was produced. And finally, on the 12th of March 2018, despite all that had gone before, despite the medico-legal reports, the obvious mental health distress and the length of his detention, Dr. Uzer Ali wrote to the Home Office stating that D643 was fit for detention, fit to fly, and was getting adequate care. This was despite the fact that he'd not examined D643, and D643 was not in fact receiving any care at all from healthcare at this time. It was careless cruelty. Finally, and just 10 days later, on the 22nd of March 2018, in a stunning and absurd volte-face, Dr. Chowdhury wrote to the Home Office and informed them that D643 was indeed in need of specialist PTSD treatment, which was not available in detention, and he was therefore not fit to be detained. That was 457 days since D643 had entered Brook House with a previous diagnosis of complex combat-related PTSD. It was careless cruelty of the worst kind. It would even be another 47 days before he was in fact released. D643 informed healthcare on numerous occasions that he was feeling suicidal, or it had been identified by members of the healthcare team as having suicidal ideations on 4 other separate occasions. No Rule 35 report was ever produced. Dr. Hard gave evidence that it was inevitable that the detention of a man like D643 for an indefinite period, day after long day, week after long week, asking for help for his mental distress and receiving none in return, would damage him. The damage was long-lasting. Indeed, it continues. D643 ended his witness statement by stating that, "When I was released from detention, I was referred by my GP to receive treatment from a psychiatrist at a mental health hospital. My faith in medical professionals had been so shaken by the treatment I'd received in the Brook House healthcare that I was extremely anxious. I did not feel able to trust the psychiatrist on meeting her. It was as though I was waiting for her to disbelieve me or to act in the hostile manner that I'd become accustomed to at Brook House. I was unable to move past my fear that she would turn out to be like the healthcare staff and doctors at Brook House, and as a result, I did not feel able to attend any further sessions with her. Even now, after 4 years later, I do not feel that I have fully recovered from the treatment I was subjected to at Brook House. I still suffer from flashbacks, in particular in relation to the use of force incidents outlined above and the way I was treated by the healthcare professionals, in particular Dr. Chowdhury and Dr. Uzali. In hindsight, nobody has or could defend the detention of D643 in Brook House. He's received damages for unlawful detention, but he's never received an apology or an indication as to what period that the Home Office accept was unlawful. Karen Churcher gave evidence that it was not an environment where it was possible or even appropriate to attempt to give trauma-based therapy, and this must have been known from the outset. Sandra Calver gave evidence that detainees did not have access to appropriate psychiatric treatments and that detention centres were not the appropriate environment to promote recovery from mental ill health. Everyone from the Royal College of Psychiatrists to Dr. Hard to even the former DCOs that you've heard from agree that it is not a suitable place for a man with PTSD or other mental health difficulties. The Home Office are apparently the only people who disagree. You've heard that it's not just that recovery is impossible for those with PTSD. Dr. Hard and others confirmed that detainees are positively harmed by being detained in those circumstances, and so it was with D643. And finally, Chair, what does D643 ask of the inquiry? Well, as I mentioned, he's profoundly grateful to have been given an opportunity to give evidence. He has emphasised repeatedly to his legal team that the simple act of being listened to, of being taken seriously, of being given an opportunity to put on the record that what happened to him, is of immense value to him. He's profoundly grateful to Callum Tully for shining a light into this dark episode of his life. As for recommendations, we will go into more detail, Chair, in our written submissions. But briefly, the system of indefinite detention harms people. It's cruel. The system of detaining the mentally ill and the vulnerable harms people. It's cruel. It does not matter what the corporate logos are on the uniforms or what banal corporate values are displayed on posts on the walls. The system brutalises those that are expected to work in it. It harms those who are detained within it, and it rewards the careless cruelty of those who displayed indifference to D643's suffering again and again. Tinkering with the machinery of this cruelty will not end it. Nothing short of a radical change will ensure that what happened to D643 and the other men you've heard from will not happen again. As for Brook House itself, Brook House is simply a symptom, a morbid symptom of a sick system, a Category B prison that's not a Category prison, a 72-hour removal centre that is nothing of the sort. It's a place of harm, it's a place of shame, it should be shut for good. Perhaps it should be turned into a museum, Chair, and future generations can visit it, read the testimonies of the men who were shut up in it, watch the footage that triggered this inquiry in the first place, shake their heads in wonder as to how it ever came to this. Thank you, Chair.
Thank you very much, Mr. Lee. I wonder whether we actually take our break at our lunch. I'm so sorry. Ms. Shinlu, are you able to give me an indication of how long you're likely to need?
I had planned on only being 20 minutes.
Okay, that's fine. Let's go ahead and do that then. I'm sorry about that. Thank you very much.
And I will do my best to keep to that.
Thank you.
make these submissions on behalf of D801, D1275, D1713, D2158, and D1473. On behalf of them, I thank the Chair, Council and solicitors to the inquiry for giving them a voice in this inquiry. If I can just say out at the outset, as a shortcut, that each one of them was subjected to a regime which Dr. Hard described as completely deprived of safeguards. It was inevitable that they would experience mental suffering of the kind prohibited by Article 3, and in particular in the circumstances where none of them knew when this situation was going to end. It was for them, the detention was for them interminable. If I can take you to D801 first, everything that the Home Office knew about D801 should have, but did not prevent him from being detained on the 1st of March. The Home Office knew that he suffered psychotic depression, PTSD, and had attempted to overdose twice in the community. The Home Office had medical evidence that a previous period of detention in 2015 contributed to this, and had they bothered to look at the reports, they patently showed that he was an adult at risk level 3, the highest level, and that he would be harmed if detained. There was no fixed date for removal, and he was not a public protection concern case, and therefore he should not have ever been in Brook House in 2017. Dr. Hard's critique of the treatment of D801 in detention speaks for itself. He said in oral evidence that, although not physically assaulted by staff or verbally abused, leaving D801 in detention for this period of time of a total of 34 days caused him to suffer ill treatment, because none of the safeguards that were meant to function removed him from detention worked. D801 was a really good example, Dr. Hard said, of a complete inattention of the understanding of the purpose of the rules and the imperative to relay that information to the Home Office at the earliest opportunity, with a mechanism that would have meant a review of detention was undertaken at that point in time. At every opportunity, the safeguards failed. There was no Rule 35(1), 2, or 3 raised throughout the entirety of his detention until the very last day, when a Rule 35(1) was completed by Dr. Chowdhury, only because Dr. Belder, the IRC psychiatrist, said unequivocally that D801 was not suited for detention. All the signs of this was apparent long before Dr. Belder made that statement on the 31st of March 2017. D801 was someone that the Home Office and healthcare knew required treatment that was unavailable in detention. Dr. Belder told them so on day 2. But this did not cause the Home Office to recognise that this was a seriously unwell man who was someone on a proper application of the adults at risk policy should not remain in detention. There was no contemplation of other alternatives to detention, namely release into the community, when a hospital transfer was declined a week later. Instead, D801 was managed unlawfully, contrary to good psychiatric care, in de facto segregation on E-Wing, subject to ACDT the whole time, at the beginning on constant watch. You have heard a lot of evidence of how this is not treatment and did nothing to prevent deterioration. In fact, in D801's case, he tried to kill himself using a shoelace as a ligature and razors whilst on ACDT. But even that didn't trigger any statutory reporting mechanisms under Rule 35. There were a total of 4 Part Cs sent to the Home Office, each uploaded onto the system, each ignored. The only treatment following his suicide attempt was advice to him on how to snap an elastic band around his wrist to help him cope with stress. It's not hard to begin to understand that this cannot be treatment of the kind necessary for him. You will recall Dr. Bingham's evidence that detention has the effect of forcing victims of torture to relive their past torture as if it was happening to them again. There is no doubt from D801's narrative to an independent expert, Dr. Sen, that he suffered Article 3 inhumane and degrading treatment at Brook House. He said, and Dr. Sen summarizes, he could not eat and was throwing up all the time. He just stayed inside his room and didn't want to socialize with anyone. The food tasted to him as if he was eating a pair of glasses, like it was burning. He didn't wish to explain anything to the authorities, just stayed away from the food. The whole experience felt to him like walking on fire. every single day felt as if it was biting on his skin and he physically felt the pain. D1275. But for this inquiry, the true nature of the ill treatment suffered by D1275 at Brook House would never have come to light. He was so severely unwell during the time he was there that he couldn't even describe his experiences to anyone in a coherent way or know how to seek help. His severe mental health issues weren't identified, managed, or treated at all at Brook House, and this was despite recurring health logs citing his bizarre and sometimes aggressive behavior, incoherent answers to questions. Even the Iranian consulate raised concerns with the Home Office about his strange behavior. Instead, and frequently, D1275's behavior was seen as refractory and was managed by segregation for extended periods of time. At Brook House, he was repeatedly referred to the mental health team and repeatedly discharged from that team's caseload. No one bothered to do the basic checks to find out why he had missed so many appointments. Karen Churcher and Sandra Culver were both resolved to say that attendance at medical appointments was a matter of patient's choice, irrespective of vulnerabilities. His non-attendance was described in terms of wasted hours and resources of the mental health team, rather than symptomatic of a seriously unwell man. Neither contemplated that he could lack mental capacity to make decisions about accessing medical treatment or speak up for himself about his detention or conditions of detention. There was no practice to do so. They didn't know how to do so. And Ms. Calver accepted, and rightly so, that this was a serious failure in knowledge and care. D1275 was just left to languish, but for the tenacity of Naomi Blackwell, a caseworker at GDWG, he could have remained in detention indeterminately in an environment that discriminated against him because the Home Office has refused to make provision for independent advocacy for people who lack mental capacity. By the time GDWG found him, he had been in detention for nearly 400 days, even though the Home Office knew long before that he could not be removed. He would remain in detention for 616 days, 442 at Brook House, before he was able to access lawyers and secure release. Dr. Hard said in oral evidence that it was inevitable that a vulnerable detainee subjected to this kind of length would suffer harm, and in fact, even someone who didn't have these issues would find it difficult and would deteriorate in an environment like this. Sandra Culver accepted serious omissions in his case, causing him significant ill treatment. His immediate hospitalization on release under the Mental Health Act for nearly half a year clearly demonstrates the extent of his mental deterioration and how unsuited he was for immigration detention. We all now know too familiarly the footage from 14th of June 2017, where he was cruelly and casually mocked by DCM Nathan Ring and DCO Derek Murphy with derogatory remarks including div, scrotum, and the more chilling and recurring phrase that's been used at Brook House, if he dies, he dies. All this while he was suffering the acute effects of a spice attack. A nurse present for the mockery didn't challenge it, in fact joined in with homies after your coke. The evidence before the inquiry shows that it was widely known that he was vulnerable and being exploited as a guinea pig for spice. No one did anything to stop it. No one reported it. They just watched it happen, and some joined in to mock him. It was callous, but allowed to be repeated because of a culture of impunity and dehumanization that pervaded Brook House, which normalized this kind of behavior and suppressed dissent. He still isn't able to speak about his experience at Brook House. When his solicitor Hamish Arno tried, he became distressed. This fragility of his mental state still is a product of the intense mental suffering he experienced in prolonged immigration detention, and an Article 3 breach is inescapable in his case. D1713 is a victim of torture, sexual and physical abuse, with pre-existing PTSD before entering Brook House in March 2017. He is a classic illustration of the lasting mental harm caused by a complete deprivation of safeguards. No questions were asked at health screening to identify any past history of trauma or torture. Within hours of being at Brook House, he was asking to see a GP because he was experiencing flashbacks from being detained. Although he disclosed self-harm ideation and torture to Dr. Chowdhury, no Rule 35.3 report was raised, and no Rule 35.1 was raised. Dr. Chowdhury could not give a coherent answer for why this was the case. He said he thought he needed to wait and see if D1713 actually deteriorated, which plainly is not what the rules say. We now know, of course, that Dr. Chowdhury didn't understand what the Rule 35 safeguard required of him as a doctor, or why, which, as Dr. Hart said, put detainees like D1713 directly in harm's way. The Home Office treated his self-harm, trauma, past torture as self-declared, of no value as far as the adults at risk policy was concerned. This reflected, of course, the culture of disbelief built into the evidence levels of the risk, but in circumstances also where the Home Office failed to ensure the safeguards linked to it actually functioned. Again, the only treatment was ACDT, which did nothing to prevent him from re-experiencing over and over again his torture in the form of intrusive flashbacks. Not one nurse carrying out ACDT reviews thought it to refer him for Rule 35 assessment, despite repeated disclosure of torture, flashbacks, and self-harm. And whilst detained, he was the target for derogatory and demeaning comments. One DCO compared him to locking up a dog. He felt humiliated, scared, like I was not being seen or treated as a human being. He was powerless to do anything because, quote, we were all scared of the consequences of speaking out. We were living in fear. Brook House was like hell. He is now scared to go to sleep at night, scared to close his eyes, fearing that the experiences that he had at Brook House would flash through his mind. Detention at Brook House spawned a severe episode of depression and has had a lasting effect, which an independent expert, Dr. Galapathy, has said has a poor prognosis for recovery. D2158's experience is very similar. He was not pre-screened before detention, despite being a victim of torture or sexual abuse. He was detained unlawfully for the whole time that he was at Brook House because there was no power to detain someone like him. Although he was liable to be returned to Germany under the Dublin regulations, the detention could only be applied to someone like him if he was at significant risk of absconding. He was not. Once detained, again, there were no Rule 34 appointments, there were no Rule 35 appointments. In the meantime, he suffered worsening heart palpitations and nightmares, and often felt like someone was putting their hands around his throat, and he struggled to breathe. The sounds of doors opening, banging, and the sounds of keys would make his whole body shake, and he would feel an electric shock in his body. He couldn't convey the intensity of his mental anguish and physical suffering because each time he went to healthcare, he was not given an interpreter. The Rule 35 assessment he finally got from Dr. Uzrali was cursory and careless and didn't address the impact of detention on him as a victim of torture who was suffering recurring trauma symptoms and heart palpitations. His report was one of 3/4 of the Rule 35 reports at Brook House at the time, which failed to address the impact of detention. The Home Office relied on that to keep him in detention so that he could suffer even more. When he commenced a period of food refusal because he felt he had no alternative, this was dismissed as a dietary issue with no investigation into his escalating trauma symptoms and deteriorating mental health. Whilst detained, he was kicked by different custody officers on 2 occasions and also bullied and demeaned. The violence was unprovoked, doled out casually with the intent of intimidating, demeaning, and humiliating. He couldn't complain, he didn't know how, and he was afraid to, because at night he often heard other detainees screaming in pain after lock-in. He thought they were being physically assaulted by officers. He didn't want it to happen to him. Such was the culture of fear of detainees were subjected to at Brook House. And finally, D1473. His mistreatment at Brook House is graphically illustrated by the prolonged and excessive restraint he suffered for some 5.5 hours during an attempted unlawful removal whilst at Brook House. Whilst the force used waist restraint belt was applied by task force officers, it was initiated on Brook House premises with the knowledge and apparent supervision of G4S and Home Office staff. There was simply no justification for this restraint. It was unplanned because there was no risk assessment to suggest he should be restrained for removal. He was compliant throughout the removal process from start to finish and presented no actual risk to anyone. And more importantly, it's another case where it should never have happened because D1473 was not removable at the time. He had outstanding representations on Article 8 grounds, and he was recognised as an adult at risk, level 3, and manifestly unsuitable for detention and on ACDT. Mr. Shaw, in 2014, in a report prepared by the Advisory Panel on Non-Compliance Management, identified the use of a waist restraint belt in these circumstances as inimical to the person's dignity. The duration and effects of this use of force against 1473 actually caused mental and physical suffering. In his own words, it was terrifying and humiliating from start to finish. I was treated like an animal you were transporting. The terror was indescribable. His is but one of many cases concerning routine misuse of waist restraint belts to facilitate the discharge of vulnerable detainees to task force officers. Other examples include the removals of 1234 and D2054, both forcibly restrained whilst naked and subsequently placed in waist restraint belts on handover to task force. The routine use of passive restraints in these circumstances with no prior consideration of the risk of vulnerabilities of the person reflected the general normalization of the use of force in the centre. It was reckless, inhumane and degrading, especially when deployed for prolonged periods of time. The entrenched failure of the Home Office and its contractors to even appreciate and recognise this is illustrated by the PSU's response to the complaint made by D1473 concerning his restraint, categorising it as a minor misconduct. On behalf of all of these individuals, I endorse Ms. Harrison's submissions on the need for urgent interim recommendations so as to bring to an end, finally, the deprivation of safeguards which continue to this day to currently affect detainees in Brook House. This has to stop, and it has to stop now. Thank you very much.
Thank you very much, Ms. Lee. Thank you. And I appreciate you keeping to that time. Much appreciated. We're going to break for lunch now, and we will return. I'm still going to keep us to 2 o'clock just to make sure that we don't slip from the timetable. Thank you. See you at 2 o'clock.